Well, good afternoon, everybody. Happy Thursday to you. Bill O'Leary coming to you as part of our Thirsty Thursday series, coming to you live here on this Thursday, August 12th, 2021. I took last Thursday off because I was out on a well deserved vacation, but I'm back in the saddle, and so resuming the Thirsty Thursday series. And so, what it is, for those of you that may not know, it's a series where I go live each week Thursday at about this time, and what I do is talk briefly about a different topic that relates to what I do for a living. I'm a lawyer. I'm an estate planning and elder law lawyer, and so I'll talk about a different topic that may be sort of in the news, or maybe something that I think you might be interested in. So if you are thirsting for knowledge, you've come to the right place. So today's topic is power of attorney for my incapacitated parents. What are our options? What are our options? So look, we all worry about our parents, and me as well, and we're worried about what's going to happen to them if they start to decline in health. Who's going to manage their affairs? So this can be a sensitive and often sort of complicated conversation that people will end up having, children usually, with their aging parents, that relates to protective measures in the event that their parents become incapacitated. And look, human nature for any of us, giving up financial control, it's a lot, and it requires a thoughtful discussion. So during these conversations that you will have with your parents, or may have, it's important to keep in mind and understand and respect your parents' sense of autonomy. That should be valued and respected. So a power of attorney is a great place to start with that conversation. So what a power of attorney is, it's a legal document that's intended to provide some authority to somebody to help you manage your affairs, to protect you in the event that you lose your ability to make decisions if you become incapacitated in the future. So having a power of attorney in place can also help avoid sort of future costly public court proceedings that may involve things like guardianship or conservatorship. So want to stay away from that. So a power of attorney basically is a written legal document where you appoint someone else to manage your financial affairs. This person is called the agent, might be called an attorney in fact as well, although we typically use the term agent because that's more understandable by people. The person who gives the power, who signs the power of attorney, is what we call the principal. So the person that signs it, let's say your parents, they're the principal, and you as the child would be the agent, okay? Now, this legal document, it specifies all of the powers and duties of the agent, and they can be broad or they can be narrow, depending on what your parents want to do. So, these powers can include a number of different things. So, for example, you might grant somebody the power to take an existing trust that you've done and put more assets in it, what's called fund the trust. You may give them the power to amend the trust. How about the power to buy and sell real estate, or maybe to invest or reinvest your money? Maybe you give somebody the power to enter into a contract for you, or maybe operate a business that you owned. Powers also over, let's say, bank accounts and retirement plans. These are very common powers that you would expect to see in a good, well put together power of attorney. Now, the document has to be signed at a time when the principal, let's say your parents, they have the legal ability to do so, what we call capacity, legal capacity. So in other words, they need to know what they're signing, okay? And usually this power of attorney is included as part of sort of an overall estate plan that may also include a will or a trust. Now, in Florida, there are certain signing requirements that have to be complied with, such as witnesses and a notary. Also important to understand that in Florida, a power of attorney is effective right away when you sign it. So you may ask, well, how else would a power of attorney be put in place? Well, there was a time where we could prepare a power of attorney that would only become effective in the future if the principal became incapacitated. So as long as the principal was healthy and was fine, the power of attorney, the POA for short, would not go into effect. That's what we would call a springing power of attorney. So the springing power would effectively state this is not going to become effective until some future occurrence, such as my incapacity as the principal. Well, unfortunately, we can't use springing powers anymore in Florida. They were abolished about 10 years ago. So that means that the agent that you're appointing under this POA will be able to use it immediately. So you better trust who you appoint. Now, what if the person that you are appointing as your agent, you don't have complete 100% trust and confidence in them, and you want to make sure that they're not going to be able to use the POA while you're still healthy? Is there a way to do that? Yes, we have sort of developed sort of a workaround to the law that we now have to deal with, which has eliminated springing powers of attorney. The workaround solution is that you would sign a POA today while you are capable, okay, cognitively capable of doing that. And then you would give it to us as the attorney. We would hold it in escrow. And there'd be very strict restrictions that would be imposed on us. We would not be able to release it to anybody, including your agent, unless we get a letter from a doctor saying that you're incapacitated. So in effect, it's sort of a way to indirectly create a springing power of attorney. Now look, this escrow arrangement, we don't do it that often. From time to time, somebody will want to do it. Although, look, as I like to tell people, if you're doing the escrow arrangement because you don't completely trust your agent, why are you appointing them to begin with? So it can be a difficult decision. Now, there's a type of power of attorney called a durable power of attorney. What is this? Well, the word durable simply means that the powers that are listed in the legal document will remain in effect even after the principal, the person that signs it, even after the principal becomes incapacitated. So the durable aspect of a power of attorney is important because the powers remain valid even when they're needed after incapacity sets in. Now, your parent may ask, well, does the power of attorney last forever? Well, you can tell them no. It is going to stop, it's going to go away, be terminated, if you will, at their death. So the moment of their death, the POA is gone, out of the picture, no longer effective. Well, while they're still alive, they are always free, your parent, to revoke the POA, okay? As long as they're competent to do so, they can revoke it at any time. So they're not locked in when they do it. Now, typically when that happens, if it's going to be revoked, there should be a written document put together called a revocation document that specifies the revocation that's taking place, and that usually is either served on the agent that's appointed in that now revoked POA, or it may be recorded. And then if your parent does execute a later power of attorney, a new one, it should explicitly state that any prior POAs are revoked. So when speaking to your parents, it's important to emphasize with them that by establishing protective measures, now they're choosing who may be acting on their behalf, and they're deciding now what specific powers they should have, a lot or a little or somewhere in between. Documents creating a power of attorney basically give guidance as to your parents' preferences, and they provide important insight as to what their wishes would be in the event they can no longer communicate. Okay? So, look, the fact is, if this planning is not done, then your parent may be placing that decision making not in your hands as the child, but in the hands of the court. We want to keep the court system as far away from our affairs as possible. So there you have it. So look, if you'd like to know more about powers of attorney for your incapacitated parents, maybe you want to know what the options are, and if you'd like maybe to know how we can help, we'd love to talk to you. So we would encourage people to go ahead and invest 15 minutes of your time. Book a free 15-minute discovery phone call. You can book it on the Facebook page. Go to the Book Now button, or just Google us. Legacy Planning Law Group. Legacy Planning Law Group. So, what this discovery call does is it gives us a chance to sort of feel each other out, whether we'd be a good fit to sort of work together. And also, you're able to share with us what your concerns are. So that way we can tell you if we can help you. So again, that call is complimentary. So as I bring this to a close, hey, if you've enjoyed this Facebook Live event, I would ask that you like this video. Better yet, would you mind sharing it with your friends? Really, would it be okay if you shared it with your friends? Because I really want to get the word out. There's a lot of lack of information, good information out there, and I think this will be very helpful. So please do share it. So I hope you've enjoyed this talk, about power of attorney for the incapacitated parent. What are the options? I plan on giving another Facebook Live event or talk next Thursday at about this time. So if you're thirsting for knowledge, we will quench your thirst. So Bill O'Leary, signing off for now on behalf of everybody here at Team Legacy. Go make it a great day and go make it a better world.